Registration Certificate Section 12. Provision related to and provided the person who authorized to buy and sell deal securities or stockbroker, share transfer agent, banker to issue, trustees of the trade, register to issue, banker, underwriter, portfolio manager, investment advisor, and other of the intermediaries who are associated with the securities market shall buy and sell the deal securities accordance with the conditions of certificate by the registered obtained by the board in accordance with the regulations made under the act. Board may by the notification specify the person who shall buy or sell or deal in securities, who depositories, participant, custodians of security, foreign institution investor, credit rating agencies, any other intermediate associated with the securities markets or the board may be notified in this behalf and shall buy or sell a deal in securities in accordance with the conditions of a certificate of registration obtained from the board in accordance with the regulations made under the act. The person who shall sponsor or cause to be sponsored to carry on the cause to be carried out by any venture capital funds or collective investment schemes, including mutual funds, shall be who obtained certificate of registration from the board in accordance with the regulations. Person who shall sponsor a cause to be sponsored or carry on acquires to be carried on activities of alternative investment fund or a business trust as defined in the clause section 2 of Income Tax Act 1961 shall be who obtains certificate of registration from the board in accordance with the regulations. Manner of application of registration. Every application for a registration shall be in such a manner as a payment of such fees as may be deemed to be by regulations. Suspension or cancel of certificate of registration. The board may by order or suspend the cancellation of certificate of registration in such a manner as may be determined by the regulations, provided that no order under the subsection shall be made unless a person concerned to be given the reasonable opportunity to be heard. Prohibition of manipulation of deceptive devices, insider trading, and substantial acquisition of securities or control. Section 20. Prohibition of person for performing following activities. No person shall be directly or indirectly. No person use or employ connection for the issue, use or employ in connection with the purchase or sale of securities listed or proposed to be listed on recognized stock exchange. Any manipulation or a deceptive device or contraventive in contravention of the provision of the act or the rules or the regulation made thereunder. Employ any device or schemes or artifact to defraud in the connection with the issue or dealing in security which are listed or proposed to be listed on a recognized stock exchange. Engage in act or engage in a practice or course of business which is employ devices or scheme or artifact or defraud in connection with the issue of dealing in security which is listed or proposed to be listed on the recognized stock exchange. Engage in the act of practicing course of business which is operate and would operate as a fraud or decide upon any person in connection with the issue dealing in securities which is listed on or proposed to be listed on the Company Stock Exchange. In a contravention of the provision of this act or the rules or the regulations are made thereunder. Engage in insider trading. Deals in security with possession of a material or non-public information of or communication with the material of a non-public information to any other person in a manner which is contravention of the provision of the act or the rules or regulations made therein. Acquire control of a company securities more than a percentage of equity share capital of the company whose securities listed and proposed to be listed on the stock exchange in contravention of the regulations made under financial accounts and audit. Grant by central government. Central government may of after due appropriation made by Parliament by law in behalf made by the board grant any of some grant of any sum or money or government may think fit to be utilized for the purpose of that fund. There shall be a constitution of fund called the Security Exchange Board of India General Fund and that shall be conducted therefore. All grants, fees and fee charges receivable by the board under the act. All sums are received by the board for such of the resources as may be decided upon the central government. Fund may be applied for meeting salaries, allowance, other remuneration of the members, or offences and other employees of the employees of the expenses of the board in the discharge of the functions under the section 11. Expenses are objective or for purpose of authorized by the act. Accounts and audit section 15. Preparation of financial annual financial statement of board in consultation with CAG India. The board shall maintain proper book of accounts and relevant records and prepare annual statements of accounts in such a form as may be prescribed by central government in consultation with Control Audit General of India. Audits and accounts of board. The accounts of the board shall be audited by the Comptroller and Audit General of India at such interval as may be specified by him, and any expenditure incurred in connection with such audit shall be payable by the board to the Comptroller and Audit General of India. Rights and privileges. Control Audit General of India as may be other person appointed by him in connection with the audit of accounts. So the board shall have the same rights and privilege and authority in connection with such audit as a control audit general has in connection with the audit of general accounts, and particular shall have a right to demand the products of production of books, accounts and connection vouchers as the documents and papers, and to inspect any of the office of the board. Certified accounts and audit report to be forwarded to central government. Accounts of the board are certified by the Control Audit General of India or any of this person appointed by him in the behalf of the in audit report thereon shall be formed annually to central government, and the government shall cause the same to lay before such house of parliament. Penalty and adjudication. Penalty to failure to furnish the information return, etc. If a person who is required under the Act of any rules and regulations, therefore, to furnish any documents or returns are returned to the board, fail to furnish same, who furnishes or files or false, incorrect or incomplete information to return report, books and other documents, he shall be liable to penalty and which shall not be less than 1 lakh rupees, which may extend to 1 lakh rupees of each day during which such failure continues, subject to the maximum of 1 crore rupees. To file any return or furnish any information, books, or any other documents within the time specified therefore in the regulation, fail to file the return or fail to furnish the same within the time specified thereof and the regulation, who furnishes or files false, incorrect, or incomplete information, return the books of accounts or other documents, he shall be liable to penalty, which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees of each day during which its failure continues, subject to maximum of 1 crore rupees. To maintain books of accounts or records or fail to maintain the same, he shall be liable to penalty which shall not less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which his fail continues, subject to the maximum of 1 crore rupees. 1 crore rupees. 1 lakh, 1 lakh, 1 crore. Wow. Penalty to failure of any person to enter into agreement with the clients. If any person who is registered as an intermediate or required under the act or any rules or regulation made therefore to enter into agreement with the client fail to enter into such agreement, he shall be liable to penalty which shall not be less than 1 lakh rupees, which may be extended to 1 lakh rupees for each day during which the failure continues, and subject to the maximum of 1 crore rupees. If any listed companies or any person who is registered as an intermediate, after having been called upon the board in writing to redress the grievances of the investor, fail to redress such grievance within the time specified by the board, such company or intermediate shall be liable to penalty, which shall not be less than 1 lakh rupees, but which may be extended to 1 lakh rupees per day, which may suffer a failure to continue maximum of 1 crore rupees. Penalty for certain defaults in the mutual funds, section 15D. Person liable for default punishment level. If any person who is dealing with a mutual fund for defaults required under the act or any other rules or any other regulations made thereunder to obtain certificate of registration from the board for sponsoring from the board for carrying on any of the collective investment scheme, including mutual fund sponsors, or carrying on any collective investment schemes including mutual funds without obtaining any certificate of registration, he shall be liable to penalty which he shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees for a which day during which sponsors or carries on any of the collective investment schemes or including mutual fund schemes to the maximum of 1 crore rupees. If any person who is registered in the board as a collective investment scheme including mutual funds or sponsoring or carrying out any investment schemes, fail to comply with the terms and conditions of certificate registration, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may be extended to 1 lakh rupees for each day during which such failure continues, subject maximum to 1 crore rupees. If any person who is registered with the board as a collective investment scheme, including mutual funds, fail to make an application for a listing of the schemes as provided for its regulation governing such list, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may be extended to 1 lakh rupees for each day during which such failure continues, subject to maximum to 1 crore rupees. If any person who is registered as a collective investment scheme, including mutual funds, fail to dispatch unit certificate for any other schemes in the manner provided in the regulation governing and dispatch, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may be extended to 1 lakh rupees of each day during which its failure continues, maximum 1 crore rupees. If any person who is registered as a collective investment scheme, including mutual funds, fail to refund the application monies paid by the investor within the period specified in the regulations, he shall be liable to penalty which is not less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which such failure continues, subject to maximum of 1 crore rupees. If any person registered as a collective investment scheme, including mutual funds, fail to invest the money collected by such collective investment scheme in the manner or within the period specified in the regulation, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which such failure continues, subject to maximum of 1 crore rupees. Penalty for failure to observe rules and regulations by the asset management company, Section 15E, where any asset management company of a mutual fund registered under this Act failed to comply with any of the regulation provided for restriction on the activities of the asset management company. Such asset management company shall be liable to penalty which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which it fail continues, maximum of 1 crore rupees. Penalty for default of such an alternative investment fund, infrastructure investment fund, alternative investment funds, infrastructure investment trust, real estate investment trust, section 15A, where any person failed to comply with the regulations made by the board in respect of alternative investment fund, infrastructure investment fund trust, real estate investment trust, fail to comply with the directions issued by the board. Such person shall be liable to penalty which shall not be less than 1 lakh rupees, and which may extend to 1 lakh rupees every day during which failure continues, subject maximum of 1 crore rupees, 3 times the amount of gain made on such failure, whichever is higher. Penalty for default in the case of investment advisor or researcher under Section 15 EB, where an investment advisor or a research analyst fails to comply with the regulations made by the board or made by the direct action issued by the board. Such investment advisor or such a research analyst shall be liable to penalty, which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees per day during which such a failure continues, subject to maximum of 1 crore rupees. Penalty for default in case of stockbroker, Section 15. If a person registered under the stockbroker fails to issue contract notes in the forms of manner specified as stock exchange for which a broker is a member, he shall be liable to penalty which shall not be less than 1 lakh rupees, which may extend to 1 crore rupees, or for the contract note required to be issued by the broker. If a person registered under the stock market fails to deliver the security or fail to make a payment of the amount due to the investor in a manner which may be prescribed specified regulation, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may extend to 1 lakh rupees for each day during which such failure continues, subject to the maximum of 1 crore rupees. Charges any amount of brokerage which is excess of brokerage specified in the regulation, he shall be liable to penalty which shall not be less than 1 lakh rupees, but which may be extended to 5 times of the amount of brokerage charged, excess of the specified brokerage, whichever is higher. Penalty for insider trading section 15G. Any industry insider trading shall be liable to penalty which shall not be less than 10 lakhs rupees, but which may be extended to 25 crore rupees, three times amount of profit made out of insider trading, whichever is higher to either on this 24 crore rupees 10 lakh 20 crores, either on which either one of these own benefit or behalf of other person, either on his own behalf or behalf of other person, communicates any unpublished price sensitive information to any person with or without the request of such information, counsels or procures for any other person to deal with security of any body corporate on the basis of unpublished price sensitive information, deals in the security of a body corporate listed on such stock exchange on the basis of any unpublished price sensitive information except as required ordinary course of business under the law. Penalty for non-disclosure of acquisition of shares take over section 15H. If any person who is acquired under section acquired under the act or any rules and regulations made thereunder fails to disclose the aggregate of the shareholding in a body corporate before he acquires the shares of the body corporate, then fails to make any public announcement to acquire the shares at a minimum price, fails to make a public offer by sending letter of offer to the shareholders of the concerned company, fail to make payment of consideration to the shareholder who sold the share pursuant of the letter of offer, fails he shall be liable to penalty which shall not be less than 10 lakh rupees but which may extend to 25 crore rupees or three times the amount of profit which made out of the failure, whichever is higher. Penalty for fraudulent and unfair trade practice section 15 HA. If a person endulges in fraudulent or unfair trade practices relating to securities, he shall be liable to penalty which shall not be less than 25 lakh rupees, but which may extend to 25 crore rupees, or three times the profit which profits made out of such practice as a fraudulent unfair trade practice, whichever is higher. The penalty of alteration, destruction, records and failure to protect the electronic database of the board. A person who knowingly alters, destroys, or mutilates, or conceals, or falsifies any makes and false entries in any information, any record, any document, through electronic records, including electronic, which is required under the Act or any other rules and regulation made thereunder, so as to impede, obstruct, or influence the investigation, inquiry, audit, and inspection of proper administration of any manner within the jurisdiction of the board. Explanation: for the purpose of this clause, a person shall be deemed to have altered, concealed, or destroyed any of the information, record, or document in the case knowingly fails to immediately report the matter to the board or fails to preserve the same till such information continues to be relevant to any investigation and continues to be relevant to any inquiry, audit, inspections, or procedures which may be initiated by the board or conclusion thereof without having authorized to do so, access to tries to access or denies of access or modifies access parameter to regulatory data in the database without having authorized to do so, downloads, extracts, copies, or reproduce any of the form of regulatory data maintained system database. Knowingly introduce any computer virus or other computer contaminant into the system database and bringing out the trading halt without authorization disrupt the functioning of the system database, knowingly damage, knowingly destroys, knowingly deletes, knowingly alters, knowingly diminishes the value or utility, or affect any of the means of regulatory data in the system database. Knowingly provides any assistance to AI into cause any other person to do any of the acts specified to me to F shall be liable to penalty which shall not be less than 1 lakh rupees but which except to 10 crore rupees or three times the amount of profit which out of the act which is higher. Explanation: in the case of exploration, computer containment, the computer virus and damage shall be meaning respectively assigned to them under Section 43 of the Information Technology Act 2000. Penalty for contravention where no separate penalty has been provided. Section 15 HB. Wherever fail to comply with any provision of the Act, the rules and regulations made or directions issued by the board thereunder for which no separate penalty has been provided shall be liable to penalty which shall not less than 1 lakh rupees, which makes into 1 crore rupees.